You needed that weapon for self-protection because it was imminent and you were in a life-threatening situation. You were not. And as applied to you, with an OWI, fourth conviction, still on probation, extreme alcohol misuse and alcohol disorder, you had no judgment no judgment to even be around firearms. Alcohol and firearms are dangerous and can be very violent. So as applied to you, that prohibition is necessary. And then you add all in your personal issues, the violence, the aggressiveness, the PTSD, those nightmares. On top of that, especially as applied to you, the prohibition is necessary. I do have to look at your rehabilitative needs and to see if you have the ability to rehabilitate, if you want to rehabilitate, if you want to change your life. Because this, as it's been stated or argued, that this has impacted your life as well. It's kind of like a shot again to the victim that it's impacted your life. Your freedom may be restricted. You may be incarcerated for a significant period of time, but one day you will be released, even if it is on extended supervision, and you won't be suffering from the lifetime effects that the victim is. Not to mention her son. The trauma of having to hear the thud, knowing the thud when he came up was his mother, knowing she was shot in the head, not knowing if she was going to live, having the fear that you could have, in whatever state you were in that day, knowing, not knowing, shot him and killed him. How you've devastated his life and his relationship with his mother. She's not able to do activities or do things as much as she was before. He now feels like he has to protect her. He now feels like he has to be the one to care for her. He's a child. He is a child who does not deserve to have to worry about these things. And now he does for the rest of his life. I want to make sure that I have covered everything that I have highlighted. As I'm looking, I do want to point out that it's a miracle. And thankfully to all that believe in higher powers, it's a miracle that Ms. Fickbaum is alive. But what she suffers from daily is worse than death. I'm not going to even expand upon the statements made about the other domestic violence with your ex-wife, or the things that I think are abuse, emotional abuse, and other things with your children, and the fact that you had them eat under a timer, because I don't have any real concrete information that either of that has occurred. Because you do state, and you have stated to the DOC agent, that you were never physically abusive to Ms. Fickbaum. You were never abusive. You were not a violent or abusive person. The PSI says that there is a lack of remorse, and I know that Ms. Fickbaum has stated that that is something that she has been missing as well, seeing a lack of remorse. Your attorney has stated that he has directed you not to speak about that. You did provide that here today in a statement saying that you are sorry for those actions and what happened. It shows some remorse. I'm not sure how much, but that shows some remorse. Now, in factoring everything together and looking at the totality of the circumstances here, and especially looking at the gravity of the offense, and not wanting to unduly depreciate that gravity, and to find a term of incarceration to meet the court's objectives, the court believes that a sentence that would not unduly depreciate the gravity of the offense to fit the crime and the crimes that have occurred. And especially because the court views the fact that you were on probation, you had a no drink of alcohol prohibition, you had a no firearms prohibition, and that one's for life. The court finds that that is an aggravation of this incident, and it aggravates what happened that day. And although Ms. Fickbaum may have engaged in alcohol consumption that day, and she may have been extremely intoxicated as well, she in no way played a factor in you taking that weapon, you taking that gun and shooting her in the head. None of that, none of it is her fault. None of it. With regards to count one, the second-degree reckless injury with the domestic abuse enhancer and the modifier of use of a dangerous weapon, the court is going to sentence you to 17 and a half years of initial confinement. That would be the 12 and a half years for the underlying second-degree reckless injury, plus the max for the use of a dangerous weapon modifier of 5 years. The court finds this to be so egregious, so serious, that the maximum possible penalty is necessary not only to protect Ms. Fickbaum, but to protect the public in general, because I have not seen that you have a desire to follow the rules and to follow the law in any way, shape, or form.
Judge, I'm interrupting. I do that at risk. You said 17 and a half years confinement. I think the maximum is 17 and a half years imprisonment, 12 and a half confinement, 5 and
12 and a half confinement. Okay, I read that on Mr. Schmidt's argument. So 12 and a half years, well, Mr. Schmidt, because it says the maximum, not more than 12 and a half years. Oh, 7.5 is the maximum. Sorry. I apologize for that. So with count 1, the court is going to sentence you for the underlying second-degree reckless injury, 7.5 years of initial confinement. And then the maximum for the use of the dangerous weapon, totaling 12.5 years of initial confinement with 5 years of extended supervision. As it relates to count 2, possession of a firearm, convicted felon, the court also finds this egregious. The fact that he knew he was a convicted felon, as applied to him, it was very serious. He was simply just on probation not too long before that. The court finds that a maximum of 5 years of initial confinement and 5 years of extended supervision is necessary. Counts 1 and 2 are consecutive to each other. As to count 3, possession of a firearm by a convicted felon, the court finds that that is still serious and egregious. No matter where the firearms were placed, he knew of the prohibition. He knew that that was for life. He was still on probation. He was on a no alcoholic drink prohibition. He was extremely intoxicated. The court is going to sentence him to 3 years of initial confinement with 3 years of extended supervision. That is consecutive to counts 1 and 2. As to count 6, possession of a firearm by a convicted felon, the court finds the same. 3 years of initial confinement with 3 years of extended supervision. That is going to be consecutive to counts 1 and 2. And concurrent with count 3. For count 7, possession of a firearm by a convicted felon, the court also finds the same things as to counts 3 and 6. 3 years of initial confinement, 3 years of extended supervision. That is consecutive to counts 3 and 6, consecutive to counts 1 and 2.
Judge, did you say consecutive or concurrent? 7 is concurrent with 6 or consecutive?
Consecutive. It's consecutive to all counts. Count 8, possession of a firearm by a convicted felon. Same basis. 3 years of initial confinement, 3 years of extended supervision. 8 is concurrent with count 7, but consecutive to counts 3 and 6, and consecutive to counts 1 and 2. In my calculation, it's 26.5 years of initial confinement, and I believe 16 years of extended supervision. The court finds this to be so egregious, so serious, and so preventable. Had Mr. Winquist recognized his problems and did something about it, he did not. He failed to do anything, and he had sign after sign after sign, and he failed to even recognize or address them. And he continued to violate the law. He continued while on probation to violate the law and violate his conditions of probation multiple ways. On extended supervision, he is not eligible for early release programming, either the challenge incarceration program or the substance abuse program, until the last 3 years of his sentence, if any. On extended supervision, absolutely no alcohol, no illegal substances, no paraphernalia, no prescriptions without a valid prescription, gainful or some type of employment to occupy his time and his mind. It does not have to be full-time. It can work with his disabilities. absolutely no contact with Christina Fickbaum or any of her family members, any residence, any employment that she may have or her family members may have. The court is also going to order that he has an AODA assessment and follow-through treatment. He engages in some type of criminal thinking, such as thinking for a change or breaking barriers. The court is ordering $12,582.23 in restitution. The court is going to order $518 in court costs and fees per count, except for count 1 has an additional $100 due to the domestic abuse surcharge. These are felonies. Absolutely no use or possession of firearms for life. No voting in any election until your civil rights are restored. Court is ordering his DNA. This is not something he can have expunged due to the seriousness of the crime. Failing to pay his fines and fees, a civil judgment will be entered. If he is released on extended supervision and has not paid his fines and fees, a warrant will be issued. He can sit up to an additional 6 months in jail. Restitution is paid, so the court is going to order at minimum a monthly payment of $150 per month until paid off in full. The court ordered court costs, surcharges, and fines are to be collected as a percentage as determined by the Department of Corrections to be reasonable while he is in a state prison. And as a condition of extended supervision, he is ordered to pay those upon release.
Why?
Oh, why? Sorry, I wrote
That's
EY.
okay.
I apologize.
That's okay. I am a friend of the family, also Christina's advocate. I have been here since March of 24, or sorry, March of 25 is when I was asked to kind of step in and help with the family. Christina did not have the ability to schedule appointments, drive anywhere. So they needed somebody to kind of coordinate all of this, and I stepped in and took that role. During the time that I've gotten to know Christina, I just love the girl. She's just a sweetheart, but I didn't know her before. So all I can say is how I can perceive her now, but she's had so many doctor visits. We had to establish primary care because she had to leave her home in Cambridge, which she lost because she didn't have any employment. So she left her home in Grantsburg and moved to Cambridge so that her son could stay with her sister. She's been to neurology. She has a TBI. She has seizures almost weekly. She had a brain bleed, which resulted in having a coil implanted. We've had psychological testing, behavioral psych testing. She's been determined that she has moderate to severe memory issues and moderate neurocognitive disorders secondary to the TBI. She's been to cardiology. She's had at least 4 cosmetic surgeries to repair the injury to the scalp. She has 2 more coming. The surgeon did make a comment that it was like putting Humpty Dumpty back together again. So that was kind of interesting because it was such a mess. The orthopedic, she has injuries to her neck and her lower back. She is now using a cane and a walker, depending on where she is. She's supposed to have a sleep study done, but she's got some trauma with that for fear of being away and being around others. She has biweekly therapy sessions for trauma, PTSD, anxiety, depression, sleep issues. Excuse me. She has 90% hearing loss, both hearing aids in both ears, and all of this is a result of the injury on May 31st. She had left Grantsburg, the place that she knew as home. She lived with her sister for a while, and her son lived with her other sister. They weren't able to be together. The home that she lost was the home that she had with her prior husband, who has since passed away. So this home meant a lot to Christina and the boys, and it's now gone. And to clean up the house, because of the damage that was done, just the biohazard cleanup alone was $28,000. That does not include repairing of the subfloor, new carpet, new sheetrock, new appliances, new flooring. That's above and beyond. Her home in Grantsburg had been robbed many times to the tune of $18,000 plus, and those charges are still pending. And that's because she was unable to be at the home. Because of the result in the loss of the home, she's incurred about $20,000 in attorney's fees, which we're not sure how those are going to get paid. Right now, her only source of income is working very part-time, and her deceased husband has a small pension. Otherwise, that is her only source of income. We've applied for Social Security disability. We've initially been denied, but we are in the process of appealing for that. She's been subject to some online harassment by the defendant's ex-wife, and also his aunt apparently made an appointment. We want to make sure that this is known to him too, and his mother. His aunt made an appointment to see Christina. She is a cosmetologist at the salon. Was very intrusive in a lot of the questions that were asked. Christina was just being very polite and very, didn't give a whole lot of information. And then as she was leaving, she turned to Christina and said, "By the way, I'm Mike's aunt," and left. That caused some serious trauma for her. No matter what happens, Mr. Winquist will be able to leave at one point and lead a relatively normal life. Christina's life has been irrevocably changed. There will be no living normal for her. She has PTSD. She has flashbacks. She has blackouts. She is fearful of being in public, or especially being around men. Her and Donovan they're doing good based on the circumstances here, but life is not normal. They're doing good, meaning that they're here physically, as to what could have happened. That's all I have for now, and thank you for your time. I appreciate that.
Thank you, Ms. Kelly. Donovan, what you can either tell me your last name or you can give me an initial.
Check.
Can you-
CZECH.
Okay. And you are the victim's son?
Yes.
All right. What would you like me to know? And I'm going to say you sound a little spoken, which is okay, but can you speak into the microphone and talk as loudly as you can and try and enunciate your words so I can hear them and so my court reporter can hear them?
Yes.
Okay.
So like, I don't really understand why it's not child endangerment is added to it. Because if the gun was not jammed, I know for sure he would have came after me because I was still in the house. I was behind like one of these walls right here. I was behind one of those.
And you're pointing to the jury box?
Well, like,
So it was that high?
no. So our stairs are on the other side, and he was over here in our house by the fridge. He could have easily, because there's no basement door to get out. So he could have easily trapped me in the basement and shot me right there. But thankfully, God saved me and my mom. For the whole night, I didn't even know she was alive or dead because they didn't give any information. And then I had to stay away from my mom 3 months. 3 months. Because she had to heal and I was living at my aunt at the time. We saw her for the first couple of days, saw her breathing tube down her mouth. She could not talk for the rest of the week after she got shot. And then the next week, she was a little bit better. And then we saw her heal and heal. But then she said, I can't hear you, Donovan. You need to speak up. And then they're thinking about that she won't even remember me ever again. But that was proven that she could remember me. It was just a hard time. We're struggling to pay bills, all because of this happened. And then we get robbed like a couple nights after. And then, I don't know. And then we expect him to come back to the same community, live his life, a normal life. He can do whatever he wants as soon as he gets out. But me and my mom struggle to do stuff that we want to do because it depends how her legs feel, depends how she feels that day. And sometimes she gets so scared at night that she comes in my room, makes sure I'm still there, and checks on me. That's how bad it is. That's how bad her PTSD is. I'm seeing weekly therapy with my PTSD because whenever she has a man over, I have to tense up or I have to get involved. It's just we can't live our life normal again. We can't trust any man that's in our house because we don't know what they're gonna do. And yeah.
Thank you, Donovan.
Yeah.
You want to come this way? All right, and you can either state your name for the record, or you can just use your initials.
Christina Fickbaum.
All right. And I'm going to say the same thing to Donovan. Please speak into the microphone just so I can make sure that I hear everything and my court reporter can too, okay?
Okay.
And if at any time you need me to turn up the system so you can hear better, if you're missing something, just raise your hand and then I'll know that I need to turn up our audio system, okay?
Okay.
You may start whenever.
You know, it took me a long time to decide what I was going to say, what I wasn't going to say, because.
And I'm so sorry to interrupt, but can you just, I know that this is, that you're in court and your anxiety is probably really high, but can you just speak a little slower too?
Sure. I struggle with it just for the simple fact that, you know, a lot of things I don't remember. And anytime that I think about Mike, everything just goes blank. I'm definitely nervous about what I should say or what I shouldn't say for fear of what will happen once he gets out, because I'm unable to file a restraining order at that time. But, you know, one of the big things that, you know, has not been brought up at all is Mike was shot. And I took care of him throughout the whole entire time. I didn't have that. You know, like they say, my life is not the same. My whole family's been impacted by this. And I feel bad because I'm like a burden. You know, I always tell people it's like in reference of when you blow out candles on birthday cake, that's how fast my life was gone. He didn't kill me, but my life left. And, you know, the other thing too that's pretty hard is that he could have very well taken another parent for my children. And the thought of that for them is just unbearable. And I'm not the same. I mean, people keep telling me I'm not the same. I don't feel the same. I guess Debbie? Can you?
I want to get one thing that I know she wants me.
Is that all you would like to say today?
She's gonna have Debbie finish for her.
Right.
Okay, and that's totally appropriate and fine. If you are going to read something, please read it slowly.
I will.
Thank you.
Okay. The one thing that bothers all of us here, I think, is there has never been an attempt for any apology. There has never been any show of remorse. And the fact that they're saying that he didn't really know what happened, pardon my French, he's full of shit. And I apologize for that. There was one thing that Christina came across that I wanted to read as though I'm Christina. You were not my partner. You were my punishment. You didn't love me. You drained me. And yet I called it romance. You didn't hold me. You caged me. And I mistook the bars for a warm embrace. You weren't my partner in life. You were the tax I paid for ignoring my worth. I prayed for love, and life handed me a lesson in scars. That wasn't fate, it was a mirror. It wasn't chosen, I wasn't chosen, I was targeted. My kindness made me a canvas for your cruelty, and my silence gave you power. You broke things in me you had no right to touch. I kept trying to heal with the same hands that hurt me. You didn't walk beside me, you dragged me. You weren't building a future, I was surviving a sentence. You were a storm pretending to be a shelter. You called it passion, but it was punishment. I watered dead things. I stitched red flags into rose bouquets. You weren't a lesson. You were a warning, and I just refused to listen. So tell me this, was that love or was it self-destruction wrapped in longing? Don't lie to yourself. And the worst part, I loved you deeply, but not anymore, not anymore. That's it. Thank you.
Thank you. Ms. Fickbaum, are you sure that you don't have anything else to say? All right, thank you. Ms. Bauer, is that all of the statements?
Yes, Your Honor. I'm of like one friend, actually. Christy Madsen is a friend, and she wants to speak.
Any objection? A close friend?
Well, did she submit a statement to the Department of Corrections in the PSI process?
I don't know.
No,
I don't recall who all did.
he did not.
She did not.
I don't have any objections.
Mr. Winquist, any objections? Nope. Okay, you may provide a statement.
I didn't catch the name. I'm sorry, Judge.
Krista Matson.
KRISTAMATTSON.
All right, you may begin.
I'm here on behalf of Christina Fickbaum. She is actually not very much able to speak for herself. And the one statement that I would like to leave the court with more than anything is that she is asking for the highest amount of sentencing that can be provided under what he has already said guilty to. And that is it.
All right, is that all, Ms. Bauer?
Yes, Your Honor.
Okay, I'm now going to turn to the attorneys for arguments. Mr. Schmidt.
Thank. Sorry,
Want to cough now?
I do have cough drops up here if you would like.
I'm good. I just swallowed wrong right at the part where I need to speak. As the court recalls, the state is free to argue in the sentence, except that the second-degree reckless with the dangerous weapon will be concurrent to the felon in possession of firearm associated with the firearm used in it. And that will be consecutive to the felon in possession of firearm charges associated with the guns in the closet, which will be concurrent with each other. That means the state is therefore capped at 12.5 years initial confinement and 5 years extended supervision on the first cluster, and 5 years initial confinement, 5 years extended supervision on the second. Totals about a 27.5-year sentence of imprisonment, which is comparable to what DOC recommended, which was a range of between 11.5 in and 18.5 in, aggregating all their consecutive counts, and 6 to 7 out, aggregating all their ESs that they recommended. The state's
I
recommendation,
think that's incorrect. That's not how I added up what the DOC's recommendation was. I believe for count 1, it was 5.5 to 6.5 in. And then 2 to 3 for all other counts, consecutive, all consecutive.
yes, I added them up, and that's what I added up to if you run them all consecutive. Unless if I read that wrong.
They're all consecutive, okay, consisting of, oh, they did 1 to 2 initial, that's right, okay.
But
I wrote down 2 to 3 and it's 1 to 2.
Judge, my understanding is that Department of Corrections recommended essentially 16.5 years.
well, they gave a range is the thing, so I was including the range.
If you go to the maximum of the range, it's 16.5 years.
Oh, well, regardless, my recommendation is going to be the upper end of what I'm capped at. It's going to be 17.5 in and 10 out, which is relatively close to what DOC recommended. In Wisconsin, for any case, for any sentence, the court must always consider probation first. It must consider something called the McCleary-Gallion factors, which is the gravity of the offense, the character of the offender, and the need to protect the public. When we actually argue this in practice, we usually break down those more abstract legal terms, those three, into more specific things like deterrence, punishment, incapacitation, rehabilitation. Those subcategories of those factors are easier to break apart and discuss and apply facts to than something general and big like protection of the public. Those factors and sub-factors, I believe, can be generally split into 2 categories. Factors are supposed to be predictive of behavior, related to the character of the offender and the need to protect the public. Those are things like specific deterrence, rehabilitation, incapacitation. Those are all things that the judge has to largely look at the facts and predict what's going to happen in the future. What is the lowest sentence that will specifically deter this offender from doing this again? What is the sentence that will rehabilitate this offender in the future so it won't happen again? If it's not possible to fashion a sentence that could accomplish those things, do we simply incapacitate the offender with a long sentence? That's what I mean by predictive factors. The other factors have to do with largely what we might call accountability or more broadly public policy. These are punishment, general deterrence, and not depreciating the seriousness of the offense. These are factors that have less to do with the defendant as an individual and more to do with the nature of the offense and its relation to the community. The public needs to know how different behaviors will be generally deterred from other people who would do them in the future. They need to know that offenses involving particularly bad morals or bad mens rea or bad impact to the victim will have that cause higher social and victim costs, will have higher penalties to satisfy the general social and psychological need for punishment, and to not depreciate the seriousness of the offense by doing something that would offend and depreciate. In both those regards, this case is largely fact specific. So I'm going to quickly overview the facts of this case as it relates to that. This is a case where Michael Winquist shot Christina Fickbaum in the head with a shotgun, not outside, not during like a hunting incident or cleaning a weapon, but for no reason at all. It was done in the kitchen, and there was no danger there. There was no home invader. There was nothing like that. In the days leading up to the offense, there were no indications that this was something that was predictable, that was going to happen. Analysis of the phones of both of them showed their relationship was good. According to the child, according to the child who was there in the home, there was no argument in the immediate lead up to it. There was an argument earlier in the day in which they were arguing about money related to the child's father owing them money and a need to possibly engage in civil suit for that. What happened is at some point in the day, Michael Winquist, who had not been sleeping for days, had been drinking constantly for days, was on what you might call a bender, suddenly was heard by the child who was in the basement, suddenly wake up, crashing around the bedroom, stumble to the kitchen. He heard a gunshot. His first thought was, well, Michael Winquist often will shoot like squirrels and varmint and things like that, until he heard a body drop. And then he went up and found the image of Michael Winquist in front of his mom with a gun with her bloody on the floor. He fled, and when he was outside, he had to watch Michael Winquist shoot himself. He wasn't sure if Winquist was dead or not. Later on, he would go back in and remove the firearm. Michael Winquist was there ineffectually doing some sort of care to the head wound while mumbling something about dreaming. The victim, Christina Fickbaum, miraculously survived. She survived a gunshot wound to the head. In fact, she walked herself out of the building to EMS outside. The injury that she really was inflicted with wouldn't become apparent until later. In fact, if you watched her right after the incident in the hospital, you wouldn't detect any sort of impairment in how she's interacting at all. None of the cognitive or neurological issues that you've heard from the victim statements today. That was an injury that has worsened and festered and grown and gets worse with time after the injury was inflicted, the initial gunshot. At that point, law enforcement asked her the question, what happened? And she couldn't remember for obvious reasons. She was shot in the head. They asked her, do you have any idea why this happened? And she couldn't give an explanation. The person who had been living with him didn't know. The best she could do was speculate it's associated with his PTSD and him fighting in his dreams. But she didn't know the answer. In the PSI, she was interviewed by the PSI writer, as well as many family members and other people who just know Michael Winquist, where it was discussed that he's violent. He engages in what one might call domestic violence, offering another possible explanation for what might have happened. Nobody really knows, though, because of the lack of memory, what actually caused this. I'm going to come back to that later. Michael Winquist at the time was on probation. He was on probation for felony OWI. He was prohibited by the conditions of probation from consuming, possessing alcohol, absolute sobriety. He was prohibited by the law because of the felony nature of the conviction from possessing firearms. In the PSI, he specifically talks about that shotgun in the closet. Why do I have it? It's for the purpose of protection. That is not allowable for someone who is a felon. You can't just keep it for protection, or else the prohibition would mean nothing. Everyone could just have a firearm then, and everyone knows that. It wasn't practical to think you could actually do that. As alluded to, as time passed, the injuries worsened. I don't think I can do a better way of summarizing the effect on Ms. Fickbaum that has already been explained by the victim, by her family, by the people who've observed her day in, day out over time. That wasn't conveyed by her describing herself as feeling like she's becoming a burden on the people around her, that her existence has transformed since then. She's living a different life than before the injury. She's been inflicted with devastating physical, mental, emotional, neurological injury. And they're an injury that worsens with time. It doesn't get better. I think what the court can gather from that is that this is a victim that cannot and will not ever be made whole, either through anything the court can order, through any restitution that Mr. Winquist could do, because the way she's going to experience life from now on is forever changed. This is, as far as I can tell, the worst injury, the worst impact on a victim I've ever seen in a case short of death. because you also have those collateral consequences described too. She was really depending on the income that Michael Lindquist gets to help try to save the house. She was really depending on she wants to be that mother that she was before to her child. It's apparent in everything she does and says. He wants her to be the mother she always was, and she's got these diminished capacities now. Even just the hearing loss can be a communication barrier for them, and that's devastating. So how am I applying these facts to my argument? This is where I'm going to start with what I call those accountability factors, because those are really fact driven. Gravity of the offense, protection of the public. So right off the bat, the need to punish and to not depreciate the seriousness of the offense is apparent. Probation has to be struck out right off the bat, even if not for the devastating nature of the injury and for the nature of the action and the danger of it, for the mere fact that he was already on probation when this happened. It would be perverse to do probation when someone commits an even worse offense while on probation. That's always a non-starter. I think it's apparent it can't be a jail sentence. It needs to be a prison sentence. It needs to be a long sentence. I thought it very significant in the pre-sentence investigation report that Michael Lindquist himself said he should be sent to prison for double digits. He recommended over a decade of imprisonment himself. That itself conveys how well it is known that for the need of punishment in this case, for not depreciating the seriousness of the offense, we're talking about more than a decade of prison. It is absolutely necessary. Because this is a case where, as Christina Fickbaum described it, she talked about lifelong injury. I'd imagine it more as and I think she used this terminology in the PSI, that she feels like she's going to be a prisoner in her body for the rest of her life. The state's recommendation, 17 and a half years initial confinement, 10 years extended supervision, that's not going to be the rest of Mr. Lindquist's life. He'll get out almost at age 50 if the court follows that recommendation. It is more than half his life that he's lived so far. It is more than the adult life he's lived so far, but it's still less than what Christina Fickbaum is going to be facing going forward, because we know the nature of her injury. It's degenerative, it's treatable, but not curable, if that makes sense for the court, if it understands that terminology. The sentence needs to be commensurate with that injury. Proportionality demands significant punishment. I'd also like to point out that the public, as I said before, these are accountability and public policy factors. The public must be generally deterred from similar conduct to this in the future. The public needs to know, to avoid the sense of outrage that would be caused by depreciation of the seriousness of the offense, that behavior like this, that has an impact like this, use of a shotgun in a house against someone in the head, in the kitchen, this needs to be met with a massive punishment. Something less than that would, by offending the morals of the community, would affect public safety, would affect feelings of community safety and public safety. That's really what these factors relate to. Protection of the public also relates to the feelings of public safety. This is where I'm going to transition into what I call the predictive factors related to the character of the offender and protection of the public. Talk about specific deterrence, rehabilitation, incapacitation. There's a reason I outlined the facts and the conflicting information about what the cause of it was, and the fact that even, let's look at the PTSD, the sleep fighting, the domestic violence, the alcohol use. None of these is still a great explanation for why it happened. These are all negative factors that could contribute to something, but there's no explanation. What is the explicit thing that happened to cause him to get up, grab a shotgun, go to the kitchen, and shoot Christina Fickbaum in the head? I've alluded to in the past hearings, that was the main thing police were trying to figure out. We were trying to find a motive. We were trying to find sense in something that was utterly senseless. And it turns out it was a folly. And that's exactly why I think these factors do not bode well for Mr. Winquist. This was not a violent action in regards to a hot argument. This was not, what we call a hot homicide where, hey, the child in the basement heard them having a loud argument and fighting and then escalating. This wasn't that. So we can't say it was that. Could have been any of the things I described. With the PTSD, what's even the source of the PTSD? He served in the military, but he served in a non-combatant role. Could it be the shooting that happened that was alluded to by the victim advocate? Well, Mr. Winquist was simply standing outside a bar. He was shot in the buttocks by a scope rifle for really no reason at all. He did nothing to deserve it. He did nothing to call for it. Imagine the impact on you that it would have. Just
That was an accident.
He has no idea of doing that. I'm explaining from his perspective. He's just standing in public and all of a sudden shot with a rifle. Like the impact on him in terms of PTSD on that. Could that have been the cause? Is it the alcohol? Was he in a drunken sleep, deprived of that, going through a PTS dream? Was this just an expansion of domestic violence that kept rising over time? A cold action that had a cold heat, if we're talking about American literature, with no planning and no end game. Was this related to stress from inability to pay the mortgage on time and the bank's actions to start foreclosure on it? Nobody has the answers to these questions. Not me, not the victim, not Mr. Winquist. Because of that, it puts us in a very precarious position when we're talking about the predictive factors. When we're talking about what sentence can the court do that will specifically deter this offender? What sentence can the court do that will effectuate rehabilitation of this offender? The PSI, the compass, says he comes back low risk. He shot somebody in the head and he comes back low risk. And that's not because DOC did something wrong. It's not because their risk assessment tools don't work. It's because we know the things that are predictive of future behavior, and they didn't predict this for this offender. Nobody predicted this was going to happen with this offender. And that's a problem. That's a problem because it makes it extremely difficult for the court to figure out what the sentence should be that would be the lowest amount necessary to specifically deter this offender. Can the court say, based on everything it has now, that 5 years or 10 years or 15? Can the court say, what is the thing that's going to rehabilitate him? With the alcohol, there's numerous references to it really just utterly ruining his life for his whole life. From starting young to getting busted down a rank in the military, to the OWIs, making him lose his right to bear arms, to this offense. As he was intoxicated, there's the blood results. It's a factor. We just don't know to the extent of how much. He's lost so much in his life to alcohol, and yet even while on probation for an alcohol-related offense, it's not deterring his behavior. It's not changing it. It's unworkable. When we look at the PTSD, there's multiple sources of it. He's aware of it. It's happening even in the description of Ms. Fickbaum about the sleeping, about the fighting in the sleep. What's he doing about it? It's something that's continuing. It's something that's worsening. It's something that's impacting the child that lives in the home, Ms. Fickbaum's child. He's been aware of the impact of the negative things on his life and not done anything to fix it. And especially with the alcoholism, we've seen a long history of inability to fix the problems on his own, in the community, through his own actions, even when it's impacting others negatively, especially when it's impacting himself negatively. That being said, there is something the court can specifically deter, something that I think everybody agrees happened and it shouldn't have. Two things, really. The alcohol I described, the thing that hasn't changed to no avail over a long period of time, but the possession of the firearm. I understand that most of the guns are Ms. Fickbaum's. They were the ones in the basement. However, he used those firearms and the firearm kept in the closet for protection that he himself said that is the purpose for why it's there. that's just disregard of law. That's just wanton disregard of law, especially allowing those things to be present when you are going through a period where you're just not sleeping, you're having psychological issues, when you are just on a long bender, when you're not making good decisions. The reason for the felon in possession of firearm laws is because people who get convicted of certain serious crimes, we've made the determination that they simply do not have the judgment necessary to safely have these weapons. That judgment's already been made by law. Michael Winquist does not have the judgment appropriate for a person to possess and use firearms. Yet he's still he's demonstrating why he doesn't. It's impossible to look at this case and not think, if only he had been following the rules of probation not to drink, if only he had been following the law, none of this would have happened. I think that's really where I felt the most sense of outrage, especially from the victim when I've talked with her in our consultations. And because how could you not feel that way? I think everyone would feel that way in that situation. Because of the lack of success over time, over the military helping him with the overcoming the alcoholism, with the supervision on the OWI-4, overcoming that, with the lack of success, I think that the court needs treatment in a confined setting. That's one of the things the court has to consider. I think we've conclusively demonstrated for the things that could be rehabilitated on him, the mental health as it relates to the PTSD, the alcohol use, the sleep things, and even the domestic violence. These are all things that need to be treated in a confined setting, and that goes towards the sentence. But the real reason why I'm talking so much about there's not a good explanation for his behavior is because that is the sort of thing we look at when thinking about incapacitation. The reason I'm recommending a 17.5-year initial confinement sentence, even though Compass and the Department of Corrections says this is a low-risk offender, is because the community needs to be protected from him. Nobody saw this coming. If you asked the day before this of Christina or her child, is she going to get shot tomorrow? None of them would have even fathomed they would have been anywhere near that. Michael Winquist's behavior is not predictable. It's like trying to predict a wild animal, whether or not it's going to strike or not. And that's the real danger, and why incapacitation, to me, overrides even specific deterrence and rehabilitation in this case. Because Christina needs time to heal. She needs time to feel safe. That's going to take a while. So does her family. The community needs to be protected from this, because there are multiple things that need to be addressed, multiple things that are going to take years. A 20-year alcohol problem does not get solved overnight. PTSD does not get solved overnight. These dream walking things do not get solved overnight, and domestic violence does not get solved overnight. Addressing these 4 things in a confined setting will take a long time. And the mere fact that we still can't say any one of these things was the cause means the court needs to be thinking about incapacitation over specific deterrence and over rehabilitative needs. I would add that, given the nature of this offense, specific deterrence itself still does weigh in a large prison sentence. We need to specifically deter this offender from firearms and alcohol when those were 2 of the biggest driving factors to him shooting somebody in the head. In sum, the McCleary-Gallion factors tell us that the court should do the maximum sentence on that reckless injury, that 12.5 years initial confinement, 5 years extended supervision. It's hard to imagine a worse way to commit that offense than this. I can't think of one. I'd be surprised if the court could. On that grouping of felon in possession of firearms in the closet, the court should do the max of that as well. It is hard to imagine a worse version of felon in possession of firearm offense for an offender other than the offender shooting somebody while possessing firearms in their home. From a fact perspective, it merits a significant response. There is no obvious path to rehabilitation for the risk that this offender poses to society because of the myriad problems he has. He's known for a long time these issues make him dangerous, and he's ignored that despite legal and professional consequences. The firearms in the closet should be concurrent to each other because they're mostly Miss Fickbaum's weapons. They are stored in the same place. It's Miss Fickbaum's home. She gets to control what's in her home. And him exercising control over one or the other and just having access to the others concurrent makes the most sense there. The possession of firearm to shoot the victim in the reckless injury conviction that resulted from the same should be concurrent to each other because they were part of the same course of conduct and because they're a parcel of the same act. And quite frankly, I think they exacerbate each other. When you look at those two things together, the felon possession of firearm where you actually use the gun to shoot somebody and the fact that the reckless injury was shooting somebody in the head, they make each other worse, especially when you're not even supposed to have the gun. For those reasons, again, I'd ask for a total sentence of 17 and a half in, 10 out, with max on the reckless, max on the felon possession of firearm, those concurrent to each other. And then for the firearms in the closet, max on those concurrent to each other, consecutive to the other grouping. Thank you.
Thank you. Mr. Harrington.
Thank you, Judge. Before I analyze pursuant to the McCleary factors, I want to add a little more context to the circumstance. And in the course of adding to the context, I must make reference to Ms. Fickbaum. I want the court, I want Mr. Mick, Ms. Fickbaum, and all of her friends here to understand that I am not in any way blaming Ms. Fickbaum. She was the victim of a crime, a very serious crime, and she deserves everyone's sympathy and concern. But she's involved, was involved, and remains involved in the context that led up to May 31st, 2024. Mr. Schmidt suggested that the circumstances of that day were not predictable. They were not predictable that day. But the facts, the background and the facts made this tragedy absolutely predictable. First of all, let's look at the circumstances of Mr. Winquist and Ms. Fickbaum. They were engaged in a presumably romantic relationship. Ms. Fickbaum's statement emphasizes that in retrospect, it wasn't romantic, it was abusive. Mr. Winquist has told me that in fact, he considered the two of them married. The initial video that I saw of an interview with Mr. Winquist and law enforcement showed him wearing a wedding ring. He wore that wedding ring for many months.
I need to stop. Is she leaving and vacating or just using the restroom?
I don't know.
I just need to ensure that I'm gonna still be in victims' rights compliance.
Needs to take a break.
Okay, we need to take a break.
Sure.
All right, let's take,
She doesn't want to hear this.
Yeah, that's perfect.
okay, this part she doesn't want to hear, but then she'll come back.
Yeah.
Okay. Mr. Harrington, you may continue.
Thank you, Judge. He wore the wedding ring in jail for months. I can't tell the court when he took it off. He considered that they were married. They weren't, but he considered it. The court is probably aware that he received a substantial financial award because of the accidental shooting. And he, pursuant to the PSI, he gave her $75,000 because he thought they were gonna stay a couple. He needed expenses, the money to pay some expenses in the house. And they needed to make some repairs. They lived together. They shared the living expenses. They vacationed together. They enjoyed each other's company. As Mr. Schmidt noted, there was nothing on the couple days before May 31st of 24 that suggested that this event was going to happen. The discovery reflected that when in the month before May 31st of 2024, there had been flirting by email between these two. But there's one other thing that they did together that made this tragedy predictable. Right together. Right together. They consumed the most destructive substance in our society, alcohol. Michael's mother told the agent that her observation was that they played drinking games. Alicia Johnson, Ms. Fickbone's son's girlfriend, opined that both Christina and Michael drank too much. They drank together. So that's the circumstance that makes this tragedy somewhat predictable. We in the court system far too often observe the tragedies that result from increased alcohol consumption. As people continue in that process, they drink more and more. They make poor choices. They engage in riskier behavior. If they continue with that risky behavior, usually that consumption leads to a tragedy, both in their lives, but oftentimes in others' lives that are just innocent bystanders. My example is the instrument of the tragedy in most instances is an automobile. This instance, the instrument was not an automobile, but it was a firearm. A Remington 870 12-gauge shotgun. So I also contend and argue that in this particular instance, the tragedy was predictable because of the circumstance, but the tragedy was also predictable when we look at the instrument that was used. During the search of the house after the crime, law enforcement discovered a number of firearms. They discovered the shotgun, which was out in the bush, and the child had thrown it there. They discovered a loaded handgun in the kitchen drawer. Loaded in that the magazine was in the butt, in the drawer. And that was Christina's handgun. They discovered in the basement closet behind a dresser a loaded Remington 30-06 rifle. They discovered a loaded .22 Marlin rifle and a loaded .22 caliber Mossberg rifle, all kept in the basement. So these folks were consuming alcohol and had loaded firearms in and about the house. The tragedy was predictable. The date was not. But the date was May 31st, 2024. All those facts came to head, resulting in this tragedy. Michael Winquist and Christina Fickbone had consumed alcohol beverage during the afternoon, and I'm making these factual statements on the basis of the discovery. They had consumed considerable amounts of alcohol. The discovery reflected that both Michael's blood alcohol, this was 0.215, Christina's was, and I'm not sure where I got this number. Christina's, per my notes, was 0.297. I don't remember where I found that, was in my notes. I rather suspect that I got that number from some electronic discovery that I received. They consumed the alcohol. They visited a neighbor. Christina was driving the motor vehicle. We don't know precisely the sequence of what happened because, according to the discovery, neither Michael nor Christina could remember a sequence of events. We do know that Michael had napped, had a bad dream, woke up, grabbed the shotgun, fired it, striking Christina in the head. He is the victim of this horrendous tragedy, no doubt. As noted, there are three factors the court must consider in sentencing a defendant: gravity of the offense, the character and rehabilitative needs of the defendant, and the need to protect the public. The gravity of an offense or offenses is generally a comparison of what the crimes are, what's the maximum penalty, and other penalties that the legislature has determined are appropriate for a certain course of conduct, the maximum penalty. And then the other thing we look at is what happened. There isn't any question that these are serious offenses. The maximum penalty for count 1, second-degree reckless injury, use of a firearm as a penalty enhancer, 12.5 years confinement with 5 years of extended supervision. Those are the maximum penalties. With respect to felony and possession of a firearm, the maximum penalties there are 10 years with 5 years of confinement and 5 years of extended supervision. Are not as serious penalty when you look at the public policy as determined by the legislature, but serious in any event. And they should, the count 2, second-degree reckless, should be more serious because it is based upon reckless injury. Whereas counts 3, 2, 3, 6, 7, and 8, possession of firearm by a felon are really status offenses. Although one could certainly argue that 2 is not just a status offense. And I concur with Mr. Smith that it should be held together or bound together with the sentence as to count 1. Counts 3, 6, 7, and 8 are status offenses because people convicted of felonies, whether it be felony non-support, OWI felony, or any sort of a felony, shouldn't possess the firearm. The legislature has made that policy determination, and it's appropriate. Suffice it to say, this is a serious offense because of what happened to Christina Fickbone. Struck on the head, the shoulder, with after the shotgun was discharged. The impact on her life is profound and permanent. These are serious offenses. There is no argument about that. Character and rehabilitative needs of the defendant. Michael is now 31 years of age. He's a high school graduate. He honorably has been discharged from the United States Marine Corps. Some of the people interviewed by the Department of Corrections agent, one person in particular, and I don't remember who it was, and it doesn't matter, said that merely because he's a veteran, he isn't entitled to any break. Agree with that? Michael agrees with that. Michael agrees with that. Michael was a United States Marine, is a United States Marine. And Marines accept responsibility and adapt their life to accept that responsibility and serve their public. Michael received his first OWI when he was in the Marine Corps, and the PSI reflects that he accepted that responsibility. He lost pay, he lost rank, he worked hard, regained the rank, and eventually was discharged honorably from the United States Marine Corps. He was injured while on active duty, receives a 90% disability benefit from the Veterans Administration. He had been employed until he was the victim of the accidental shooting in 2021. He contributed to society. He contributed to the household. He was a substantial contributor towards the expenses of the household. And as noted, Ms. Fickbohm provided care for him in his rehabilitation. During the healing from the gunshot wound he received, he had too much time on his hands and money. And if we look at the course of his life, he began consuming alcohol at 12. It became problematic at 15. His alcohol consumption probably declined during his Marine Corps service. But after he was shot, he had too much time and the alcohol spiraled out of control. He was convicted of OWI 4, and that did change his life because it doesn't appear that he was particularly driving on May 31st of 2024. Michael didn't have a father figure growing up. His relationship with his own father was strained. He only saw him sporadically. His mom was a single parent and was working, and Michael and his brother really had to take care of themselves, discipline themselves, and had brotherly disputes. People learn their parenting skills from the parents that they have. There was much discussion in the PSI about Michael's disciplining of children. Michael's using a stopwatch to make the kids eat in a specified time. Judge, having been a United States Marine myself 50 years ago, that's what drill instructors did. Was it right? Then it was. Is it an appropriate parenting strategy? No. But that's where we're at. And Michael. Mr. Schmidt mentioned the PTSD-like trauma or diagnosis. The evaluator for the NGI evaluation diagnosed him with a trauma and stressor-related disorder. It may qualify as a mental disease or defect, but not sufficient to not to an extent to support the NGI defense. The evaluator opined that Michael Lindquist may be appropriate candidate for mental health and or substance abuse treatment. You know, that was an interesting opinion from the evaluator, but the court, Mr. Schmidt and I have all worked in this business for many years. And we didn't need an evaluation that tells us that when we look at all the facts here. Michael's not perfect. Made mistakes. He loved Christina Fickball. It was love. Michael does want the court to know that not everything said about him in the PSI is an accurate characterization. He is very much remorseful. The agent concluded that he had no remorse because sometimes Michael hesitated when he was answering questions. Victims, DOC agents, judges, prosecutors. Judges and prosecutors know this more than others. Clients are instructed by their lawyers to be very careful with what they say in jail to agents and others. When we started the PSI process, I told Michael to be truthful, to not blurt out answers to the agent's questions, and to take his time. Did that. And Ms. Lineweber drew those conclusions, but that's the explanation for his hesitancy and that sort of thing. Michael's going to read a statement. Ms. Fickbohm and her advocate outlined that Michael has never apologized. And again, that's at my recommendation. Any statement a defendant makes while has jeopardy can be used against him either at trial or at sentencing. One does not make statements that can create more legal issues when you're facing these sort of circumstances. I mentioned that the characterization of Michael's relationship isn't entirely accurate. I mentioned that Michael wore the wedding ring. He has her name tattooed to his chest. He says that his name at least one time was tattooed to part of Christina's body. He gave her the $75,000 to pay her bills. He commingled his veteran benefit and paid a large share of the living expenses. He wasn't always employed, and he helped her, and she helped him. Specifically, he denies the characterization from his ex-wife. He tells me that that was not, at the end, a pleasant experience for him or her. She, according to Michael, holds a great deal of acrimony to him. As the court can see from the PSI, the children went back and forth between Wisconsin and Oklahoma, sometimes by legal order and sometimes by, come and get these kids, I'm tired of them. And that's her saying that to him and him saying that to her. And then when most, at the time of this incident, the children were living with her. Finally, Michael admits these crimes. Stands ready to accept the court's punishment. Protection of the public. That is that third McCleary factor. And we all know what the case law says. It says that if appropriate, community supervision ought to be the first disposition. Does Michael Winquist need to be incarcerated for 30 to 35 years, as many think, to protect the public? No, he doesn't. Is his underlying personality and substance abuse dependency issues so severe as to preclude treatment within the community? No, it's not. Would not imposing a period of confinement unduly depreciate the gravity of this offense? And there isn't any question, the answer to that question is yes. The profound impact on Ms. Fickbaum, the use of a firearm, possession of a firearm as a felon, all those facts suggest that there needs to be confinement here. Just, it's appropriate now that I comment on a couple things that Mr. Schmidt said. And Mr. Winquist knew he had this post-traumatic stress type disorder. He knew he was an alcohol, consuming alcohol to excess, that he was an alcoholic, that he had substance abuse issues. He knew that he had bad dreams. He knew that the firearm was there. But we see people like that all the time. People that have substance abuse issues, they can't solve it in a day. It's not a logical question that they have in their mind. I'm a drunk. I'm going to go get cured, and it happens. That isn't what we see. General deterrence, in my opinion, doesn't work. If there's a severe sentence here, isn't going to change the fact that somebody else that drinks too much and that keeps loaded firearms in and about their house isn't going to have the same tragic circumstance. That isn't how general deterrence works. Specific deterrence, I agree with Mr. Schmidt. Specific deterrence deters this particular person from this particular behavior. So there does need to be a period of confinement to not depreciate the gravity of what happened here. Dramatic impact on the victim, continued consumption of alcohol, and the possession of a firearm. With that, how long should Mr. Winquist be confined? Department of Corrections has to count one. Department of Corrections, with respect to all counts, did not recommend a maximum penalty as to any of them. That sort of surprised me a bit. But the Department of Corrections, the agents, the supervisors are familiar with all the law that we have, everything we've talked about, all the dynamics of substance abuse, mental health issues, and the range of penalties for these similar type crimes. As to count one, the Department of Corrections has recommended as a maximum in their range, 8.5 years, 6.5 years of confinement, 2 years of extended supervision. As to count two, the department recommended 3 years imprisonment, 2 years confinement, 1 year ES consecutive to count 1. Then counts 3, 6, 7, and 8. The department continued with that 3 years as to each, 2 years confinement, 1 year ES, but all consecutive to each other. I agree with the Department of Corrections analysis, with the exception is counts 3, 6, 7, and 8 should be concurrent with each other, but consecutive to counts 1 and 2. That's the analysis of the Department of Revenue, Department of Corrections. Their status offenses, the firearms for counts 3, 6, 7, and 8 weren't in the bedroom. They were downstairs, in a closet, behind a dresser, loaded. They were loaded. At no time during the investigation of this were those firearms tested to see if Michael actually touched them. There weren't any fingerprint analysis. There was no DNA analysis on the firearms. If you look at the photographs of the firearms, there was rust all over those things. They hadn't been cleaned. They hadn't been properly preserved. So there should have been some effort to investigate and determine if Michael actually touched them after his OWI 4th conviction. That's why I emphasize that these are status offenses. They were in the house. They were available if he wrestled around for them. He's a convicted felon. They shouldn't have been there, but they were. And that's the basis for those convictions as to counts 3, 6, 7, and 8. I urge the court to adopt the Department of Corrections recommendations, with the exception that counts 3, 6, 7, and 8 be consecutive to consecutive counts 1 and 2, but concurrent with each other. Judge, I started this conversation, this argument, with noting the tragedy. And it truly is a tragedy. Could it have been avoided? Yes, but it would have taken Michael to recognize his substance abuse. Did not. And we're here. And that's what this is for. On final note, Michael paid the $10,000 initial payment on restitution a couple months ago. He tells me he sent another check for $2,582.23 to the court just within the last couple of days.
It
The
was
restitution
confirmed.
request has been paid.
It has been confirmed that that has been paid. So what is the total initial and total extended supervision you are requesting?
10 years, 4 years ES. 10 years initial confinement, 4 years ES.
All right.
Actually, 10 and a half years, Judge. I'm sorry.
Okay.
6.5 on count 1, initial confinement. 2 on count 2, initial confinement. 2 on counts 3, 6, 7, and 8. Count 2 consecutive to count 1. Counts 3, 6, 7, and 8 consecutive as to counts 1 and 2, but concurrent with each other. We believe that satisfies the needs and is appropriate. I have calculated his credit days through today at 565 days, including today. Thank you, Judge.
So 564 because you don't count today.
564. me she asked that.
All right. Mr. Winquist, I'm now going to turn to you and give you an opportunity. Actually, I'm going to wait to see if the victim would like to come back in. All right, the victim is now back in the courtroom. Mr. Winquist, I'm now going to give you an opportunity to tell me anything that you would like me to know. This is where you can state anything that you've heard that's been inaccurate, or you can go into more depth about things that have been argued or stated or that are in the facts in this case. This is where you have the ability to show any remorse or anything of that nature. You do not have to give a statement today, but it is your only opportunity. If you are going to read something, please read it slowly, enunciate your words, and please speak into the microphone.
Okay.
You may begin.
Thank you. I would like to make an apology.
Harrington, can you please move the microphone closer to him?
I'd like to make an apology to Christina. I'm beyond sorry for what happened that night. It's so unfair what happened to you, and I will regret that moment for the rest of my life. I think about it every day and hate myself. I would give anything to change the outcome. I'm deeply sorry and hope the best for you. I would also like to apologize to Donovan. You should have never had to deal with that trauma, that situation. Very sorry. And also to all your family and friends that I've had to take care of you because of my actions. I know none of this changes anything for you, and I will mourn this for the rest of my life. Sorry.
Is that all?
Yes, Your Honor.
Let me tender this to the court reporter so she can double check.
Yes. Would you like that filed as a document or just with the court reporter for record of the record?
You can file it as a document, Judge. Then,
Okay.
then it'll be there.
Then she has a copy, she'll get a copy, and then the court will have a copy. Okay, thank you. The court has reviewed the PSI multiple times. I've highlighted, I've taken notes. I've read this so that I could have a better understanding of you, Mr. Winquist, a better understanding of the victim and victims here, as well as a better understanding of what happened or what people believe happened that day. Your attorney has stated, and the state has as well, the factors, the things that the court has to focus on when it comes to sentencing. Number one is the nature and the gravity of the offense. How serious is the case? Is this matter? I have to look at your character, your prior criminal record, any rehabilitative needs or other things with you. I also have to look at the need to protect the public. And here it's twofold. It's the victims as the public, as well as the general public. Because I believe everybody can state that this is true, that alcohol and firearms is very serious. And it's a threat not only to the people in the near vicinity, but it could also pose a threat to people in the general public. That's why we have separate, firing a firearm while intoxicated and other crimes related. It's serious. The court also has to look at the effect on the victims. Again, your rehabilitative needs, any undesirable behavior patterns from you, your culpability your age, your education, the history. And as Mr. Schmidt pointed on, as well as your attorney did, deterrence. There's two types of deterrence: general deterrence, to generally deter others from thinking about doing something similar. And there's specific deterrence, deterring you specifically from committing this crime and other crimes. I have heard and considered the arguments from both attorneys. I have heard your statement. I have read again the information contained in this pre-sentence investigation report. I have heard multiple victim impact statements. And it's a lot for the court to digest. You have admitted here to these very serious crimes through a plea agreement with the state. Count 1 was amended down from attempted first-degree intentional homicide, domestic abuse. It was amended to a second-degree reckless causing injury with a domestic abuse enhancer, as well as use of a dangerous weapon enhancer or modifier. You pled guilty to that offense, and you have pled guilty to 5 other very serious offenses of possession of a firearm by a convicted felon. When the court first tallied what prison time was originally hanging over your head, I arrived at approximately 130 years if the court did a maximum possible penalty. Because if you were to have been convicted of the original charge of attempted first-degree intentional homicide, domestic abuse, upon conviction, you may be sentenced to a term of imprisonment not to exceed 60 years. And then that was amended down to the second-degree reckless injury with the domestic abuse enhancer and the dangerous use of a dangerous weapon modifier, where the maximum possible penalty could be the initial 12.5 for the second-degree reckless, with the ability to increase an additional 5 years of initial confinement because of the use of the dangerous weapon and that modifier. All in all, due to the agreement that you've reached with the state, the plea agreement, you essentially avoided a life sentence if you were convicted on all of the original charges. Ms. Fickbaum does not have the same ability to avoid that life sentence. She will continue to live with this day in and day out, not only the emotional turmoil and effects, but the physical effects that she has and will continue to suffer from, which then leads to financial effects and other mental health effects and other things that will seep and continue to seep into her life for her life. And as she stated, you may not have killed her, but her life left her that day. And another thing that she has stated in the PSI is that now she is a shell of her life. She has no home, no car, no money. She cannot live by herself because she cannot manage bills. She forgets things. She falls. She has fear and anxiety It is a life sentence for her. The primary dispute here today is not whether or not the court sentences you to prison. Both sides agree that this is a prison sentence. It would unduly depreciate the seriousness of the incident and the offense that has occurred. But here the court has to look at all of those factors and all of those things to determine what is an appropriate sentence in this case. Because the court must order confinement at the minimum amount, which is consistent to protect the public based upon the gravity of the offense and your rehabilitative needs. There's not a formula that does that. I can't type it into an equation and have it shoot out an idea of what is an appropriate sentence. And I know the Department of Corrections has something with their compass, some ability to do that. They don't just pull their numbers out of the air. And I know Mr. Schmidt made a comment as it related to your compass. I don't rely heavily upon the compass scores, and I'm not sure how thoroughly your attorney went over that with you of what that means or what that is, but I don't rely heavily on the compass rating or the score. I don't necessarily think it's evidence-based. I don't think that it gives a real idea of the defendant and their ability or lack of ability to stay crime-free. Here, your compass score showed a low risk, that you would be a low risk to commit more crime and violent crime. And that's coming from an incident where you had a gun, a shotgun, and you shot your girlfriend in the head. So that's where the compass really doesn't come into play, or I can't rely upon it heavily, especially because the compass in other serious crimes, such as child sexual assaults or offenders or child pornography cases, those individuals also generally show a low risk. So I can't gauge based upon that. What I have to gauge upon and what I have to look closely on is your history, whether this is an aggravated incident, an offense, if there's aggravating factors. I have to look at your ability to rehabilitate, your ability to understand the seriousness of your actions, and not just your action in this incident. We all know that this is extremely serious. There are allegations of domestic abuse between you and the victim and you and your ex-wife. I don't have anything that confirms that. I don't have that you have a criminal history as it relates to that. I don't even have a criminal history of violence with you. It's all alcohol related for the most part, except for perhaps your 2018 conviction for obstructing an officer. But if I look at the underlying facts, I'm going to guess it probably had alcohol relation. And you're nodding your head up and down, so that tells me it did. You have an alcohol problem. You are an alcoholic. You cannot, you should not in any way, shape, or form ever touch a drop of alcohol. And I have to go to a statement made by your counsel as it relates to your operating while intoxicated fourth offense, fourth conviction, which is a felony. it was stated that that OWI fourth conviction changed your life. I don't see it changed your life at all. Not one bit. You continued to drink alcohol while you were on probation. You continued to engage in other activity that you were prohibited from while on probation. The only thing your OWI 4 conviction changed your life in was it took away your right, your privilege, actually, your privilege to be able to operate a motor vehicle and have a driver's license, because it took it away for life. But I'm going to tell you, I don't believe for 1 minute that you didn't drive illegally after your OWI 4th conviction. Perhaps you didn't on this day, as your attorney said, because he said this changed your life because you were no longer able to drive, and it appears he wasn't driving the day of the incident. That's the only thing that it perhaps changed your life. Maybe you didn't drive that day, or we have no facts that suggest that you drove that day. But the fact that you couldn't abide by your probation conditions, the fact that you continued to drink alcohol after your OWI 4th conviction while you were on probation, the fact that you continued to possess firearms when you are a convicted felon, leads me to believe that you wouldn't follow the lifetime restriction of no driving or having a driver's license either. So I don't think your OWI 4 conviction changed your life. If it had, perhaps we wouldn't even be here today. I do know that that day did change the victim's life. It changed her son's life. It changed her entire family's life. She now feels like she is a burden. She's not the same person she was previously. And she feels she never will be. And I know that it was brought up in the PSI and was brought up in arguments here today and from the victim herself, that you were shot with a rifle during an incident. I remember that day, not that day, but I remember that incident very clearly because that impacted your OWI 3rd conviction in front of me. That incident occurred when you were at a bar. You were standing up outside or something like that. The individual was cleaning his rifle in a house across the street. There was a cord on the floor. He was walking with the rifle. Somehow the safety wasn't on and it was loaded. Those are no-nos. But he tripped and fell. The gun shot through his glass sliding door, shattered the door, went across the street, went to the area on the bar's property where you were and struck you in the buttocks. Accident. It was an accident. This incident was on purpose. It wasn't an accident that you picked up a shotgun, you pointed it at your girlfriend at the time, you pulled the trigger, and you shot her in the head. That wasn't an accident. No matter how many people don't remember what happened or the incidents that occurred that day, or what was going through your mind, that was not an accident. Yours was an accident. Your PTSD, if you have it, and that's been said that it could be from that, or it could be from this or that or the other. Any trauma that you have suffered from your shot in the buttocks, completely, 100% totally different than the trauma that the victim here suffers from. Because she had somebody who said, I love you. She had somebody who said, from the words of your counsel, you thought you were married. You wore a wedding ring and you pledged yourself to her life, to her betterment, to make her a better person and to have this life. And you picked up that weapon that you had no legal right to possess, and you shot her in the head. It was not a heat of the moment type of incident. We don't have anything that from the juvenile who was there, who heard fighting all day, who heard a huge fight, and then all of a sudden a shot. He was downstairs in the basement playing a video game. He didn't hear that. You have had alcohol issues since you were 12. I know that it's been stated that that's when you started using alcohol, and it didn't get bad until you were 15, and you didn't have a problem until 15. But I'm going to tell you, starting drinking alcohol at the age of 12 is bad. It shows an issue. And again, you nodded your head up and down. It is. That was the start of your downfall. And whether or not your consumption of alcohol decreased while in the Marines, which again is kind of hard to believe because of the stories I've heard of people in service. Even if it did, once you returned and you were honorably discharged from the Marines and you came back, that's when it started again, not from the date of when you got shot in the buttocks. Because again, I remember that because as I took your OWI third conviction and I was being lenient to you in that conviction and was going to allow you to not have to sit in the jail for the 48 consecutive hours by law you're required to do, to serve that on an electronic monitor because of your injury. I took your conviction, you went up to jail to be processed, and you blew a 0.2 something. You were beyond legally drunk when I took your OWI third conviction. So I had to redo that conviction to ensure that you remained sober. And no, I did not allow you to get out on monitor. That's where I found an error in the PSI. You had to sit in jail. I did not allow you to be released on monitor because that was serious as well. So your alcohol issue is what has gotten you here, in part, because both sides have argued and stated that you ignored your issues. You ignored the things that were going on in your life and with you. You ignored your alcohol issue. You ignored the PTSD that you felt. You ignored the violent nightmares that caused you to have outbursts. You ignored all of these things. And it put others at risk. And again, I want to stress, it didn't only put the victim and her family and son at risk. It essentially could have, serious harm could have occurred to the public in general because of this. Alcohol and guns do not mix. And the fact that you were convicted of an OWI fourth offense of felony, you were told you were still on probation. You were told that you could not use or possess any firearms. That meant it's not all on Miss Fickbaum's shoulders because it was her house. You live there too. And as you said, you felt she was your wife. It's not all on her shoulders. You as the felon, you on probation, you are the one who knew that any weapons in that home needed to be under lock and key, or they could not be in that home. And you were not able to have access to that key. It's not all on Miss Fickbaum's shoulders because that was her home. You are the one who knew exactly that you could not use or possess firearms. Yet you did. And the argument or the statement made was you had the shotgun to use for self-defense. That is not an excuse. That is not a reason to have an exception for a prohibition to firearms. There would be if your life at that moment.
What started as a routine status conference quickly turned into one of those courtroom moments that shows there can still be hope when someone finally decides to take control of their life. The first case involved Keith Johnson, who appeared before the court after his attorney confirmed that they had received the discovery, reviewed the evidence, and discussed an offer from the state. According to the proposed resolution, Johnson would need to complete an alcohol course and write an apology letter before the case could be resolved. The judge carefully went over the plan and made sure everyone understood what needed to happen next. Johnson was given time to contact the program coordinator, complete the required courses, and return to court for a tentative plea and sentencing. It was a relatively calm moment, but it showed that sometimes the court is willing to give a defendant an opportunity to address the issues behind the case rather than immediately pushing toward a harsher outcome. But the next case brought a completely different kind of energy to the courtroom. Lee Rogers appeared by video for his status conference, and before the legal discussion could even begin, there was a small problem with the technology. The judge noticed that Rogers was having trouble with the mute and unmute functions, so the court briefly turned into what the judge jokingly called Zoom 101. Rogers explained that he builds buildings and apparently was not too familiar with the technology. Instead of becoming frustrated, the judge patiently walked him through the process, asking him to practice muting and